Can you use a trademark before it's approved by the USPTO? The short answer is yes. Hi, I'm Jason Rosenblum, intellectual property attorney, protecting my clients' products, their brands, and their businesses from getting ripped off. In this video, I'll go through a couple of questions here on Quora that relate to trademarks. So, first one, as I said, can you use a trademark before it's approved by the USPTO? And the answer is yes. However, it's always a good idea to conduct a search, a full clearance search, to make sure that you're not infringing on another's rights. Right now, at the time of taping this, it's August 2022. You're looking at about a 7 to 9 month wait between the time of that you file an application and it actually gets reviewed by an examining attorney at the U.S. Patent and Trademark Office. So you won't know what their conflicting mark search comes up. That being said, is even if you go through the trademark office clearly, there still could be an issue with another company out there that they might feel you're infringing on them. So it's always good before you ever use a trademark, whether it's a business name, a product name, a slogan, a logo, that you at least conduct a clearance search. Next question. Can I trademark a business name not registered with the USPTO? It's not my business, but the name is perfect for my business. The question is not 100% clear, but you can file for any name you want at the USPTO. It doesn't have to be your business name. You could always do business under assumed name. And in the US, in most states or counties, you have to file something as a doing business to let the state know that you're doing business under something other than your actual business name. That being said, I don't know what else the question wants. I made an uncorrectable error on my trademark application. I'm going to submit a new one to correct that. They don't have to waste their time looking at that one. How can I get the USPTO to dismiss the previous application? Okay. So once you file an application, it's very limited in what you can do in terms of amendments to that application. So sometimes there are errors that are uncorrectable, and the only way to correct it is by filing a new application. What you can do is file an express abandonment of that application. What I would suggest, and probably depends upon what the uncorrectable error is, but sometimes there's an additional statement. You can at least just wait until you file the new application to then file for the express abandonment. But while you have that one pending, you might want to just state that you also own that application. So, next question. What happens if a company's trademark is pending and I start a company with a similar name during that time? So, there's a few things you look at for likelihood of confusion or infringement. And one of them is the mark itself, the brand, the name, and also the types of goods or services. So if they're completely unrelated and there's no relation whatsoever, then you might be fine. Now, of course, that's very fact dependent. But if it's assume for the purposes of answering this question that it is the same type of a business and that there would be likelihood of confusion. So what happens if your trademark is pending and I start a company with a similar name during that time? Depending upon what type of trademark it is, if it's based on use, meaning they had a prior use when they filed the application, they're going to have priority in use over you. And if they came after you, they would most likely win out, whether it's a lawsuit or whether you decide to file a application after them. If they filed what's called an intent to use and they don't have use yet, that date of that intent to use application acts as their constructive use date, meaning should they actually prove use at a later date and get a registration, their priority date goes back to the date of filing, meaning if anyone uses it after that date, they would be infringing. But if you were using it before that date, you might have priority over them. So if it's just a pending application for an intent to use, and you started a business with the same name, you can either wait and see what happens. Do they ever file their statement of use? Does their application get rejected? could get rejected for a lot of reasons that they never obtain a registration. But you have to consider, are you going to start building your brand now, knowing that this is over your head, that you have to think about that. Do you want to spend a year or 2 years building a brand, spending money and investing time and effort into this brand, and then they get their registration and you receive a cease and desist letter? So it's just some of the things to think about. Please, in the comments or reach out to us, let us know if you like this format for answering some quick questions here, and feel free to subscribe, and you can always reach out to us at jhrlegal.com. Thanks.